Hi, everyone. Harry here to talk about Ken Chesebro's motion to dismiss. So this is a motion to just dismiss the whole charges against him, saying that, he hasn't done anything wrong and he hasn't committed a crime. Now, you remember who Chesebro is, right? He's the architect of the whole phony elector scheme and the push on Pence. He's the guy out in the provinces writing the memos that John Eastman is using. All right, he has now come in and said, in a short motion with hardly any case cites or anything, he says, my case should be dismissed under the doctrine of justification. And if you know anything about that, you might be scratching your head now, and with good reason, because it seems completely far afield from his case. Justification is a doctrine in the criminal law that says you haven't committed a crime if you basically acted for a greater good. So, and a classic example would be self-defense. You intended to kill someone. That would be homicide, except you were defending yourself from immediate use of deadly force on you, or other kinds of things where you're defending your property. As I said, the Chesebro motion has hardly any authority, but one that it does have is a case in which a guy is arrested for driving without a license for the umpteenth time. He doesn't have one. Well, but it turns out his wife is in labor pains, and he's racing her to the hospital. The court said, at least arguably, you could think about justification there, not that this is contrasted with the legal category of excuse, where you did the crime, but you've got a good excuse that maybe lets you off the hook or reduces the punishment. For example, the excuse and possible defense of insanity. So Chesebro's going all in, but if you stop and think about it for a moment, it just doesn't have any purchase or applicability to his crime. He's charged with joining a conspiracy to keep the Biden's rightful votes from going to him and instead going to Trump, and with writing these memos that, by his own admission, especially one, were bold, audacious, and controversial, or also counseled to break the law and break the Electoral Count Act, everything we do in the Constitution for the peaceful transfer of power. So stop for a second. What's he saying here? Even if somehow he wants to make the general claim, which he's been doing and will do, I was just acting as a lawyer. There's got to be, for justification, some greater good. I mean, somewhere in there is some argument that we had to kill the Constitution in order to save it. There's nothing else would make sense, that somehow his delivering of lawyerly memos was justified the same way that acting in self-defense would be justified. There's a greater good that society would recognize. The greater good here is exactly the thing that has gotten him in the soup. It's actually the attempt to unlawfully deprive the voters, not to mention the winner, of their rightful place. So this is really, it's hard to overemphasize how inapposite and kind of crackpot this is. And it's weird what's happened to Chesebro. So Chesebro was known early on. He went to Harvard Law School, and he is Professor Lawrence Tribe's. He's one of his coterie of research assistants, and those tend to be real hotshots at Harvard. Now people's political views change, but presumably he was a somewhat thoughtful, sophisticated lawyer. And this is the second paper that he's filed in the case, and they both of them were really like, what are you talking about? A motion to sever, also from others who want a speedy trial, was similarly like, completely divorced from the sorts of arguments you need to make. He said Sidney Powell had nothing to do with my case, but that's not a reason to sever. So there's some kind of, he maybe has lackluster lawyering, but he himself, you would think, would be able to brief it. It's just strange, the really low level, and just objectively, of the writings that he's producing to the court. So anyway, I can't imagine that Judge McAfee, before whom this is filed, will have much trouble denying this and saying this isn't justification. No matter what, even if your conduct isn't criminal somehow, because you were just giving lawyerly advice, which is what you want to say, that definitely wouldn't mean justification. But his overall pitch in there, and this is what we're going to be seeing from him, is he's just doing what lawyers do, just, exploring options and letting clients know the panoply of possibilities. And it just so happens that one, it turns out to be the equivalent of an unlawful coup. And that's the one that in the indictment, they make a really, they really hammer home a particular memo he writes when it's no longer about exploring possibilities. It's really exhorting this illegal option, which is why he's there. So it's our first motion to dismiss. There's going to be a ton of them. It's on behalf of Chesbro, who is one of the two people supposedly going to trial, and the jury being picked next month. And it's really lousy, and will not give McAfee much pause. And then the general point: what's the deal with Chesbro? Maybe we'll find that out. Maybe we won't. We know for sure he doesn't want to be going to trial with Sidney Powell, but he's asked for his speedy trial rights. They've been given to him, and that's where things are going for now. So we'll see, but I would predict that McAfee will not have much trouble or take much time to deny Chesbro's motion. And then there's, we'll see what else is up his sleeve. But so far, it's been really puzzlingly weak. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.